just get started with the logistics. So I'm Avi Zevin. I'm a senior attorney at the Institute for Policy Integrity. Thank you all for staying with us through the first set of speakers and panelists. I have the pleasure of moderating this distinguished panel of legal experts to talk about legal issues surrounding carbon pricing in organized wholesale markets. So let me tell you a little bit about the format, which is going to be a little different, and then we'll just jump in. So like the last panel, we'll be doing questions by card. So if you have any questions as we go, feel free to raise your hand, and someone will be passing out cards and collecting cards, and then they'll make their way to me for the question time. What we're going to do is we're going to start with a sort of a scene-setting presentation from Bethany Davis-Noll, who's the litigation director at Policy Integrity. She's going to give us an overview on some of the Federal Power Act legal issues so that we're all sort of starting in the same place. And then we'll have some conversation, some questions for the panel about that topic, and some audience questions on that topic. And then Danny Cullenward who's a lecturer at Stanford University, is going to do a 10-minute presentation on the California experience and the legal issues surrounding that experience, which are a little different than some of the Federal Power Act considerations that Bethany's going to present on. And then we'll do some panel discussion and some questions there. And then if we have time, we'll have like a lightning round of last-minute questions to get a few things in at the end. So like I said, if you have questions, raise your hand. You'll get a card, and we'll do those in the question time for each panel topic. And other than that, so I mentioned Danny and Bethany. In addition, we have Kate Konschnik, who is the Climate and Energy Director at the Nicholas Institute. And we have Romany Webb, who is a senior fellow at the Sabin Center for Climate Change Law. I'm not going to do their bios, but they are in this super useful bio and program little sheet that you can get at the top of the stairs. All right, so without further ado, Bethany, do you want to get us started on the Federal Power Act?
Thanks, Avi. Thank you all for having me, and thanks to everyone for coming today. We're so happy to be doing this with you. Okay, so this is my plan. So I'm going to give you all some nuts and bolts and sort of, as Avi said, lay the sort of groundwork that we'll need to talk more on this panel and on the panel after lunch. So that's my goal. And as I do that, I'm also going to provide sort of a perspective, like an economist perspective on the statutory authority question. So I'm a boring old lawyer, but I'm really lucky that I get to work with a lot of economists and sort of through that work see the world in a different way. And we are talking about paradigm shifts a lot here today. So that's what I'm going to try and do for us today too. Okay, so the question has to begin with statutory authority. You know, FERC isn't authorized to do anything except what Congress has told it can do. This is how we keep agencies in check, otherwise they'd run amok. So that's the basic question. So how do we figure that out? So the statute, the Federal Power Act tells us that FERC's job is to regulate public utility rates and charges and any rules and regulations affecting those rates and charges and make sure they're just and reasonable. So that's the basic rule. And where does FERC do that? It does it in the wholesale markets. This goes back to the history of regulation of electricity. You know, it used to be a state job to regulate the electric sector, but then states weren't allowed to regulate cross-border electrical sales, and so FERC was born, FPA was created. And the Federal Power Act makes clear that states have the FERC has authority to regulate wholesale electricity, but not sales, not any other sales, no authority over local distribution, and no authority over generation, you know, siting and the like. And this has been sort of clear in the case law as well. States have long-standing authority over generation facilities and any other sale besides wholesale electric sales. But obviously, you can probably tell that's kind of it turns out that's a very difficult thing to understand because this is not a hermetically sealed environment. You know, there's like all sorts of potential for overlap. And so how do you tell where the line between federal and state authority is? And what we've learned through case law and development of case law is that what FERC regulates is what happens on the wholesale markets, and no matter the effect. And what states regulate is, as I said before, generation facilities. And states have that authority even if it has an incidental effect on the wholesale markets. So they can affect each other as long as they're doing something within their authority. Okay, the states and the feds. And the reason we have this rule is because the FPA preserves the longstanding state authority in this area. And there's just no platonic ideal, I'm quoting case law, of two separate worlds. We can't see it that way. We have to just accept the fact that they will potentially affect each other. And so I think, there's two good examples that show how this can work. Demand response is a good example. And in the case of demand response, the Supreme Court found that yes, regulating those programs was within FERC's authority. You look at FERC's order and you see that the justifications that FERC gives for regulating demand response are all about and only about the wholesale markets. And then you can also look, as another example on the state side, at zero emission credit programs. Those are subsidies that states are paying to nuclear plants to keep them in business so that they will be able to have the benefit of avoiding more intense carbon emissions if the nuclear plants close. And those programs are all about something that's within state authority, emissions and generation and paying for that. And it is clear from those orders that the states aren't trying to change the wholesale rate, because the orders that have been upheld in court don't require the nuclear power plants to participate in the wholesale markets when in order to get the subsidies. I'm assuming this audience is sort of familiar with what I'm talking about, so I hope that's okay. Okay, so those are two really good examples that help you understand how this interplay works. Okay, so, Commissioner Glick raised this theme earlier, and I thought that was really helpful of him. Because of this interplay, there's a potential for arguments about preemption to come up, almost at any time when you're talking about states and the federal government and regulation of electricity. And I just to lay the groundwork for later discussions, these are the basic rules. States will be preempted if they're trying to stand as an obstacle to the accomplishment and execution of the full purposes. That's conflict preemption, and then there's field preemption as well. But this is a special area of law, okay? This is not any old area of law. As I just pointed out, states have long-standing authority in this area. So it's not just a typical preemption analysis that you're doing. What you're looking for is a clear statement in a statute that says that states are preempted from doing something that's within their traditional area of control. You can't look for like some implied preemption here, because this is state. State programs to reduce emissions, state programs to increase certain kinds of generation and change the generation mix are all programs that are within traditional state control. And people worry about carbon pricing sometimes, because that is the feds kind of potentially doing something that will affect what states are doing, or the states will be doing, then other state programs might be at risk. But you're looking for a clear statement of congressional intent to preempt state authority. That's what you're looking for. Okay. So another conundrum that we face is, how can you tell what FERC regulates? And in this, the Federal Power Act says authority over the wholesale market and practices that affect, rules and regulations that affect the wholesale market. And that could literally mean everything. So how do you tell where the line is? And what the Supreme Court has done is give us a direct effects test, helpfully, because the direct and indirect line is always so clear. So the bottom line here is, this is what we've got right now, and what we look for is, what are you directly regulating? FERC is allowed to regulate rates and rules and regulations that directly affect the wholesale market. And that's how you tell where the line is, because if you've got something that's sort of an indirect effect of the regulation, then it wouldn't be included. So for example, let's say an interconnection agreement that FERC approves is going to increase, is going to change the environmental, so is going to cause an environmental impact downstream of whatever river where the hydroelectric plant is being installed. That environmental impact is an indirect effect of the interconnection agreement, and that would be outside FERC's authority to address. But direct impacts aren't. So let's talk about that. That's where I want to sort of put on the, as I said, I'm not an economist, but I want you all to imagine that you're economists so you can see things from their perspective. It's always so simple and beautiful when you do that. Okay, so backing up. So let's talk about the history of regulation. Okay, so FERC used to use cost-based regulation to deal with the electric sector because you had a natural monopoly, large costs going in, and then costs go down as you provide your product. And with a natural monopoly, you regulate using cost-based rates, right? You let the generators recover their costs plus a fair rate of return, and that's what FERC was doing for a long time. But then competition seeped in, and FERC has moved away from that now. Now we're not regulating under the Federal Power Act using cost-based rates and natural monopoly principles. What we're doing is we're using the concept of efficiency. So when you think about efficiency and you're an economist, you think, okay, so we're looking for, we need to have a competitive market, and in order to have a competitive market to get efficient rates, you look for market failures. And there are 4 traditional market failures that economists look for. Market power, asymmetric information, and externalities, and public goods. Those are the 4 categories that you would look for if you're an economist. And since FERC is looking for sort of efficiency in its pursuit of just and reasonable rates, it just makes sense that they would look for those market failures. So let's start with market power. So FERC has done a lot in this area. The open access order, which requires transmission, which requires facilities that own transmission lines to provide open access to competitors, is a good example. Then you've got, FERC's work in the lemon law area. Asymmetric information is something FERC does a lot about, requiring information disclosure. With asymmetric information, one party to the transaction has information that the other party doesn't have. So you get more transactions that are of low value than you should, and fewer of high value than you should. So FERC's in this area too. So it's all about efficiency. And then we've got public goods. Fireworks are a great example of a public good. You invest a lot to blow off fireworks, but everybody can enjoy them. They don't have to pay to see them. You can't exclude people. And grid reliability in the area of electricity is a good example of that. So you just scratch your head and you're like, well, what about externalities? Okay, so externalities, I'm sure you're all familiar with this concept, but it's where the true sort of social cost is greater than the private cost. So you get more transactions at a lower cost than you should if you were taking the marginal cost to society into account. Hopefully I didn't screw that up. Like I said, I'm a lawyer, so just forgive me. Okay, so this is something that FERC has thought about. There's things like congestion, grid congestion, which gets factored into orders. And an externality hinders efficiency. So this should be something that if you're pursuing efficiency, if you're in a world where you're pursuing efficiency to have just and reasonable rates, this should be something that you can factor into your decision making. So I just want to leave you all with some theories of jurisdiction, one being the one I've just laid out, that can launch us into this discussion. The first theory is, CO2 emissions directly affect the marginal social cost of each additional unit of electricity generation, and so you should factor that into the bids. Another theory, which we'll discuss more with the panelists, is state policies that are intended to reduce carbon emissions can be harmonized with the federal wholesale rate, and there's a theory there that FERC has authority to approve those kinds of programs because harmonizing helps sort of improve efficiency or improve competitiveness or deal with sort of conflicts. And then another is, so a state just imposes carbon pricing and generators are facing costs, and those costs can be included in the generator's bids. This is like the simplest one that is happening. And this one also affects sort of the bids because those costs are included in it affects dispatch because those costs are included in the bids. It's the simplest version. So with that, potentially intense setup, I would like to have a discussion about these jurisdictional theories.
Okay, thank you, Bethany. So that's a good setup. And then I think what we'll do is we'll have questions for the panel, some reactions. And I'm going to actually leave this slide here because I think maybe we'll start here. The one at the bottom is that Bethany laid out, that states through state law have imposed some sort of cost on carbon that then has to get reflected in the market, is a lot similar to at least part of what Don talked about in his presentation. Let's put a pin in that one for a minute. We're going to come back to it. There are some legal complications that I want to talk about, but they're of a somewhat different kind than the sort of type of legal theories, the first two at least, that Bethany laid out. Danny, in his presentation, is going to touch on some of the sort of complicated legal implications of that last theory. So let's stick to the first two, which I think you could characterize as the RTO, either on its own or at the direction of FERC after a complaint, would sort of sua sponte implement a carbon price under a theory that doing so is within that FERC would approve under the theory that it's doing so is FERC jurisdictional, and that it maybe it makes rates just and reasonable or deals with undue discrimination, these kinds of theories. So Bethany laid out one having to do with the economic efficiency of correcting externalities. The harmonization one is another, and Romany, I wonder if you might jump in and give your view about what that theory might look like, or any other sort of legal theories that would be grounded more in the FPA than in state law with respect to the carbon price.
Yeah, and I should say at the outset that my thinking on this and what I'm about to say is informed by some work I did with Steve Weissman at UC Berkeley, and also with Justin Gundlach, who was formerly at Columbia and is now defected to NYU, which we are still annoyed about. But that work with Justin really identified sort of two broad arguments that could, in theory, potentially justify a carbon pricing scheme on the basis that it's just and reasonable under the Federal Power Act. The first, both theories are to some degree related with, and I think build off the theory that Bethany put forward. The first one sees carbon pricing really as a way of enhancing the operation of the wholesale markets, and as Avi said, harmonizing market operation with state policies. So you can think about that in a few different ways that I think Bethany flagged, but I think about it in terms of competition. So, currently the competitive landscape is skewed not only by the fact that the markets don't price carbon, but also by the fact that states have attempted to do so by through various out-of-market policies that apply in partial and sometimes inconsistent ways. In New York, we have the RGGI program that was talked about earlier. The allowance auction process really assigns a price to emissions from some, but not all, fossil fuel generators in the state. That price is really low currently. We also have, say, the ZEC program, the Zero Emission Credit Program, that implicit in that is a much higher carbon price that applies to some but not all nuclear generators. And so because we have this sort of partial application of state policies, and because they create these disparate price levels, that affects the competitiveness of different generators. And so you can think of carbon pricing as really a way of removing the advantage that some operators have and making sure that the markets remain competitive in light of those state policies. So also a kind of related argument that carbon pricing would incentivize investment consistent with the state policies. So, you know, of course, a key goal of the markets is to incentivize appropriate investment, and the way that happens is through market prices, which ideally reflect the full cost of reliable operations. And so, you know, thinking about how the markets factor in the reliability, the carbon attributes of different emissions is important. Happy to talk more about that, but I'll leave it there.
Yeah, so maybe we can just open up to the panel anyone who has a reaction to the kind of two sort of FPA-focused legal theories that we've sort of discussed so far.
I'll just jump in really briefly. I want to come back to the state stuff later, which is where I spent a lot of my time. But just to echo what I heard from Commissioner Glick this morning, there's a very big difference between a Federal Power Act Section 205 theory and a Section 206 theory. And for the non-lawyers in the room, most of the big FERC orders that set rules about market access have been 206 findings, where the Commission says we lack something. The lack of that good thing is unjust and unreasonable. Therefore, we require the good thing. And so some people have talked, and one of the theories that gets talked about is the lack of a carbon price unjust and unreasonable. I think there's a very clear intellectual argument for that. From a legal perspective, it is a much steeper barrier than a 205 filing where a single ISO or RTO comes in and says, please do this carbon price, whether because in the case of something like New York, it's coming through our process, or in the case of some of the other carbon pricing authorities, is rooted more in original state statutes specifically targeting this. But again, I think emphasizing the difference between 205 and 206 is really important, because 205 is much, much easier. And I'll say I'm a very poor law professor because I think law is politics. There aren't any votes for a 206 filing right now. I mean, that's just realistically what we're talking about. So 205 is the world I think most about, and I think that, again, is a very different legal barrier than the 206 theory.
Dan, just before we move on, can I just, for the benefit of the non-lawyers in the room, do you or does anyone else want to just say a little bit about the legal standard under the 205 sort of approach or the 206 approach and how they're different?
I will fudge it up on as little sleep as I've had, so if somebody else wants to jump in. The most important thing is it's much easier with 205.
Okay.
Yeah, I mean, I think with 205, it would be that FERC would have to see that a proposed tariff is just and reasonable, whereas if FERC is going to issue a 206, they'd have to first find that the absence of the carbon price makes the wholesale rate unjust and unreasonable, and then they would be correcting that with a carbon price. So just 2 steps, 2 is more than 1, that makes it harder.
And you'd need a record in order to demonstrate that, right? So some of what we may want to talk about and what we can maybe talk about in the next panel is the kinds of records that you would use to justify that. Kate, it sounded like you had a reaction to some of the theories that we were talking about here.
Yeah,
do you want to jump in?
Absolutely. And first, I don't know if this is because of Bethany's theory that the world for economists is simpler, but I thought it was funny that all the lawyers brought a lot of paper with them to this panel, whereas the economists just flew without paper. So I don't know what that says about us as a profession, that we need this. But I guess when Romany was just talking about competitors, it just reminded me of the Cree case. So I just wanted to mention that, you know, there is this DC Circuit Court case that's often invoked as a potential barrier to something like carbon pricing. For those who haven't read it recently, it was the Cree Indians in Quebec had intervened and then had petitioned the DC Circuit to contest a market-based rate that FERC had approved for Hydro-Quebec on the theory that that market-based price would be a good thing for Hydro-Quebec, would induce more exports to the United States market, and then in turn might cause Hydro-Quebec to build more hydro, which would then have environmental and cultural impacts. It was a standing case, but it has a lot of unhelpful dicta for people who want to see carbon pricing in a tariff or in a FERC 206 order, because it talks about how, you know, environmental issues are not sort of in FERC's lane. But it was from 20 years ago, and as we all know, the markets have changed a lot, the market players have changed a lot, and the policies that are affecting the markets have changed a lot. So just two things. When you were mentioning competitors, the court really focused in 2000 on the aggrieved party standing wording in the Federal Power Act and said, really the only aggrieved parties in RTOs can either be competitors or consumers, and neither of them care about the environment. So it's all about keeping costs down and sort of balancing the one wanting to maximize profit and the other wanting to keep costs down. And there's also conversation in there about electricity being completely fungible. And I think something that has changed a lot in 20 years is who's at the table, who are the market participants, and the concern about environment. I mean, I think Nicole is exactly right technically that there's no such thing as a green electron, but tell Apple that, tell Walmart that. There are a lot of consumers with big purchasing power who see a difference between generators that are carbon-free and generators that are not, and this is a market attribute that now some of those competitors want to see reflected in the marketplace so that the full value of their product is reflected there. So I think that that's just a way of thinking about that Cree case, that it reflects a moment in time in 2000, and we may have a very different context right now.
Yeah, just a reminder for anyone who wants to ask questions, there are cards coming around, so feel free to raise your hand for those. Bethany, do you want to say anything about, so the Cree case and this sort of, there's a, I don't want to call it a trope necessarily, but a statement that you hear often from FERC that they are not an environmental regulator and that might create some limits for what they can do. How do you think about those limits and how that interacts with the theory about externalities that you presented?
Yeah, is this on? we're all struggling. Yeah, I think that's a good question. I mean, I sort of alluded to this in my presentation. I mean, I think we look for direct effects and then we leave out the indirect effects. So the Kree case, what it represents to me is a case about indirect effects, the downstream effect on fish from building this hydroelectric facility. And those kinds of indirect effects are best dealt with under NEPA. And that's sort of what those cases are about. They're about whether FERC should be doing a NEPA analysis and how much the NEPA analysis should change things. And that's how you deal with these indirect environmental effects. But what we're talking about with carbon pricing is a direct effect on the marginal rate. It's like, since I'm a lawyer, I need notes. It's a price that that is tagged specifically to each additional unit of energy that's produced that is external to that transaction. And so it's much more direct than something downstream in the river. That's a pun and not a pun. So that's the dividing line. But I mean, as always, direct versus indirect, those are difficult concepts to separate. I understand that, but unfortunately, that's where we are with the Supreme Court. So that's how I see the line there.
Can I just
please
make one comment on that? I mean, I agree with a lot of that. When you were saying it was as much a NEPA case as anything else, I also think it was a jurisdictional case because it was in the context of a rate case, the petitioners asking for FERC to weigh in on a generation decision that was a speculative generation decision. Mm-hmm. And so I do think there was, while it wasn't really spoken, I think there was also a concern about, that very much being a power, as you noted earlier, reserved to the states by Congress mm-hmm. to make those generation choices. And I do wonder if at some point we're talking a lot about action by FERC or FERC jurisdictional markets sort of moving into that generation selection space, but there's also the inaction and when it begins to frustrate the generation selection policies of states, whether that's also sort of running into jurisdictional issues.
Yeah, can I jump in? So, yeah. I mean, one thing I think about a lot is whether even the harmonization theory requires some analysis of FERC's role in pricing this external cost. It needs to be something that affects the efficiency of the markets and the competitiveness of the markets for it to fit within FERC's role in approving a rate or a tariff or whatever. And if we're talking about something that's harmonizing, I think it's important to sort of look at whether you also need to understand FERC's role on pricing externalities in order for that to work.
Yeah, I think that's a good point, and that's why when I talk about this, I do frame it in terms of the competition angle, because I think that's really the hook that you need to link it to the efficiency mandate. But I also think that it has these other benefits, as we talked about in terms of incentives for investment, that are maybe not quite as central to what FERC has done on the wholesale markets before, but is very much aligned with things that it's done in other contexts. So, for example, in the transmission context with the public policy transmission planning requirement, very much akin to the type of thing that carbon pricing would do in the wholesale markets as well.
Can I ask a follow-up to that? So one prospect that Commissioner Glick raised this morning was what happens if the states don't feel like that the carbon price is harmonized the market sufficient to achieve whatever outcomes that they're looking for. How does that affect the legal analysis about whether the carbon pricing rule would be just and reasonable or within FERC's authority?
Yeah, I will confess that I came in partway through Commissioner Glick's talk this morning, so I missed most of it. But, you know, I did hear the end, and I thought he raised a very valid point that even a carbon pricing proposal is not going to address all of the problems or challenges created by state policy for the markets. You know, I think to some degree this comes back to Danny's point that if you're operating under a 205 and you only need to show that the new rule is just and reasonable, you don't need to show that any previous or alternative rule is more just and reasonable. So I think that does to some degree help.
I'll just add, I mean, I don't think anyone has a carbon price or is talking about a carbon price that gets anywhere near the level of ambition of what states are doing on clean energy and climate policy, and I don't see that changing in my lifetime. So from my point of view, I think it's a good question. I don't think it's the right way to look at this problem, because in no way is a carbon price going to actually solve those problems on its own.
So can I ask a follow-up to that? That's an interesting point. If FERC were to approve a carbon price under an RTO tariff, and it's lower than the ambition that the state policy has, either a state carbon price that is higher or a different level of carbon reduction through clean energy subsidies or other policy, are there any preemption implications for FERC approving that carbon price, or maybe put a different way, how can states avoid the risk of preemption concerns in that context, if there are any?
I'll start. I'm sure a lot of people have something to say about this. I mean, I think, you know, when you're talking about preemption, you're first of all, as I said before, you're talking about an area of traditional state control. So you need a clear statement of authority to preempt these state programs. And as you've all said, I mean, these programs, and as Commissioner Glick said, these state programs have multiple goals, you know, beyond carbon emission reduction, multiple goals, almost all of them. And I mean, I guess for ZECs, maybe not, but most of the others have many, many, many goals. And as Commissioner Glick said, it would be very problematic to say that regulation or, you know, a carbon pricing program at the federal level preempts things that are within states' traditional authority. So the way I see it is, you know, the states do what they're allowed to do, and FERC does what it's allowed to do. If its order is all about and only about the wholesale markets, that's fine, and it might have an indirect effect on these state programs, but that doesn't mean the state programs go away.
So we have a lot of good questions. I want to have Danny come up and do his presentation, and then we can come back to some of these issues and the overlap. And some of the ones that we talked about were asked, so thank you for that.
You got it. Well, thank you, Avi. Thanks for everyone for being here. My name's Danny Cullenward. I teach at Stanford Law School. I'll also mention I'm a member of California's Independent Emissions Market Advisory Committee, which advises the state on its cap and trade program, and our committee chair, Dallas Bertraw, is also here in the room. I'll be speaking just for myself today and not on behalf of that committee as a whole. So what I wanted to do, and I'll do this really briefly because I'm actually much more interested in the discussion and the back and forth with the group here. When I was asked to join this panel, I thought, well, it's actually really interesting. There's only one FERC-approved carbon price in the entire United States, and I don't see people talking about it as much on the East Coast and the process by which that came to be. So I'm going to run through some of the mechanics of how that works, and I think raise some of the issues, because we don't just have the Federal Power Act concerns. We also have how the states that implement a lot of these climate and clean energy policies actually address a lot of the issues we've been talking about. And I think that additional layer of the states being involved raises a number of complexities along the lines of the question already introduced. And I really should just say at the start, I mean, I don't see anyone anywhere imposing a carbon price that comes anywhere near the level of current effort on clean energy policy, let alone what's required to decarbonize the sector. So I am all in favor of market prices, and I'm all in favor of rowing the boat in the same direction. But I think it's really important not to lose sight of the fact that this is not the horse on which we ride to decarbonization. This is one of the supporting policies and not the only one. So I want to cover 3 quick questions today. So how does the CAISO energy imbalance market work? How does it actually incorporate the carbon price, which we heard a little bit about this morning? This is the only FERC-approved tariff in the country that explicitly includes a carbon price. How does the Air Resources Board in California, which manages the climate program, the cap and trade program, address issues of liability and greenhouse gas emissions leakage in the context of this explicit carbon price? And what happens when you sort of put these 2 things together? And as a reminder, this is a picture from CAISO's website of the current territory of the energy imbalance market. The current energy imbalance market and its expanded future planned entrants that have committed to it, we're getting very close to much of the Western grid. This is a very light market in its current form, but the discussion is whether or not to make it a unit commitment day-ahead market. And I think the most important thing to highlight here is the radical difference in policy and political priorities of the states that are contemplating working together in a single market. And I think if that can be done well, that's an extraordinarily powerful thing. But these are states that have very, very different politics and policies. Accommodating them and incorporating them is not a simple matter. And the reason this is a little more complicated in California compared to on the East Coast is that California includes electricity imports in the liability structure for its cap and trade program. And as the gentleman from CAISO mentioned this morning, assigns a default emissions factor to emissions that can't be traced to a particular source that's based on a 10 or 15-year-old calculation that frankly doesn't represent the operation of the Western grid at the moment. I think this is particularly important to consider as there's more and more public-based research about how to accurately track emissions, as well as the roles that ISOs and RTOs could play, providing a more granular, real-time, and accurate calculation of the flows of electricity and emissions on the grid. We have a very static system in California that doesn't capture the dynamics in the hourly and seasonal changes in an increasingly renewable grid in the West. This is maybe the most important slide I want to show you. And this is the structure of the different kinds of transactions that occur in CAISO and the energy imbalance market. If you are a power plant located in California and you wish to either sell electricity into the core CAISO market or potentially export it in some capacity, the carbon price is implicit. It is built into your bid structure because no matter what you do, whether you have a bilateral contract or you participate in the wholesale market, you are given a liability, you are assigned an obligation in the cap and trade program for your emissions. And it's done implicitly, so the price effect in the market is, again, implicit rather than explicit. The only explicit carbon price that's in a FERC-approved tariff in the country is in the energy imbalance market. And again, as the gentleman from CAISO mentioned, it's a voluntary structure, and this is really critical because if you are a non-California state thinking about participating in these markets, you probably don't want to be subject to the carbon price, at least in the present moment. And so voluntarily, generators can elect, they can opt in to be deemed dispatched to California, and if they don't do that, they're not considered eligible to be dispatched to California to serve the higher price load that's there and to receive the corresponding emissions liability that follows. So it's a voluntary structure that allows basically a choice. If you are outside of the carbon pricing zone, you can choose whether to participate in it, and that is not a simple matter from an optimization point of view or from an emissions accounting point of view. So the way this is done, again, as was mentioned earlier, is there's a facility-specific bid adder that takes the facility's emissions. So if you are a natural gas power plant, you say, these are my emissions, and this is the secondary market price for carbon. You multiply them together, you get dollars per megawatt hour, and it's very straightforward in the bidding structure to use that. The problem comes down to the question of emissions leakage. If you apply a carbon price essentially at the border of the state, and you allow people to voluntarily opt into this participatory structure, you encourage low emissions resources to opt in and high emissions resources to opt out, and you potentially get this issue of leakage or secondary dispatch. It is, again, not a simple matter, and I want to recognize here that CAISO has done, I think, some very important and thoughtful work trying to get at different ways of managing these issues. They initially proposed a fairly complex and I think sophisticated concept called the two-pass proposal. They would literally try and adjudicate the additionality and the leakage issues that come up in real time. This proposal was criticized by, among others, Bill Hogan, who published a paper on it and eventually wasn't adopted. And the sort of solution that was put forward was to throttle the volume of electricity that could be deemed dispatched from the energy imbalance market to CAISO, in no small part because the climate regulator treats all of those emissions ultimately as unspecified resources. So if you're a wind power plant that is dispatched from Wyoming to serve California at load, at least as the algorithm in the EIM does this, the importer is treated as though he or she is importing unspecified power. And that is more or less the structure we have in place. Last thing I'll mention, the two citations at the bottom of this slide. California's actually had a border adjustment in its electricity sector, and it fell apart. And if people are interested in border adjustments, I highly recommend looking into this because it's quite hard to do in practice. And it's been very, very difficult to implement. So the last thing I'll say is when one gets seriously, when one takes seriously the challenge of implementing state-level climate regulations that care about net emissions impacts, that care about imports, that care about leakage, you add onto this question of Federal Power Act authority a series of questions about how the state environmental regulator is responding. And this is critically important in the context of California, and it's also relevant in the context of RGGI and the PJM states that are considering these issues. There's a whole bunch of consistency issues that come up, and I think more legal issues come up as a result. I'll just mention, if one is trying to take leakage seriously, the idea that somebody, whether it's the ISO or RTO or the state policymaker or an independent group or whatever, could calculate the leakage impacts and translate that in a neutral way into the climate policy regime seems to me to be a fairly reasonable way to address these problems and minimize legal risks. But it's very complicated to do all of this. Again, if you want to take the leakage issues seriously, as many policymakers do at the subnational level. So I think I'm going to stop there, and I look forward to the conversation with the group in the audience.
Okay, thanks, Danny. That's helpful. So maybe if we can just pick up from the point at the end about the additional legal issues that that are raised when you try and do not only carbon regulation within a state, but also address the potential emissions leakage in a multi-state system, electricity system. Can someone give us a little bit more detail about what the legal issues are? What's the standard? What is the sort of, where do those legal issues come from? Kate, do you want to jump in here?
I'll is this on? Yeah. I'll start, but then everyone else can jump in as well. I mean, I think you are alluding to the Dormant Commerce Clause.
I am, in fact, yes.
Of the United States Constitution. Some of the Supreme Court justices we have today do not believe in it, so which is important because that is, it's not actually in the text of the Constitution. The Constitution just talks about how Congress has the right to regulate between the states and tribes and other countries. And so from that, there's sort of this dormant sense of states cannot invade that space. But it's definitely a form over substance rule, I would say, which is why people like Justice Thomas have such criticism for it, besides the fact that it's not literally written into the text of the Constitution. And so I think it is something definitely to be careful for, but it is something you can design around. The one thing I did want to say, though, Danny mentioned this briefly at the end, but I think it's worth emphasizing that the Dormant Commerce Clause applies to the state regulator. It would not apply to a market. And I think that's really important to note if we're thinking about who it is who's figuring out the border adjustments or sort of import-export decisions. And some might say, well, there are some markets that are coterminous, they're boundaries mostly with one state, they're very bound up in the governance of that state. But I think the CAISO v. FERC case stands for the proposition that once an RTO or ISO is approved by FERC as a public utility, it is a legally distinct entity. And so I don't think you have the same Dormant Commerce Clause challenges if it's the market who's making these decisions. But on the state side, there is this pesky thing that may or may not exist called the Dormant Commerce Clause. And there's a 3-part test. One is, and this really grew out of moving from the Articles of Confederation to the Constitution, not wanting to have each of the states sort of operating like its own separate country, competing with the other states, but wanting the United States to be a common market. So the number one rule is don't discriminate. So don't sort of set up barriers to trade of products from other states. And so that will definitely come out as we talk a little bit more about the California story. 2, extraterritorial regulation is a no-no, so having a state reach beyond its borders to wholly outside transactions and regulating those would run afoul of the Dormant Commerce Clause. Some of Danny's mentioning of EIM and playing in the California market being voluntary is critical to that because it's not California forcing a generator in Utah to participate. It's saying, hey, we've got this market here, we've got higher prices here. If you want to come and play, you will have to be subject to this regulation. And then if you can pass those 2 sort of hurdles, it's not discriminating against outside-like products, it's not an extraterritorial regulation, then it's a balancing test and sort of looking at the putative benefits, what the state says it's doing this regulation for, and then whether that's outweighed by an undue burden on interstate commerce. So some classic cases there are states that have said, the number of rail cars needs to change, from state to state. Like we only allow you to have 10 cars behind a locomotive. The next state says 12, the next state says 9. And the fact that would really start to balkanize our market factually because someone would have to read the rules as they got to each border and change. So I think I'll stop there. But all of those, particularly the first 2, have been implicated in conversations about sort of import and export considerations related to climate policies.
Let me just add, if you don't mind. So if you work, again, on the state climate policy level, incumbents attack you constantly on the Dormant Commerce Clause. And I agree with Kate, the issues are well characterized and they're familiar to litigators and regulatory lawyers working in this space. And I think if I can leave folks with one message, it is that the challenge of doing all of this right, which I think is interesting and worthwhile to talk about, is a question of getting the people who know that piece of the puzzle well, who are often in the environmental regulators and the allied NGOs, together with the FERC lawyers, which is a distinct population of practitioners who know something very different, together with the environmental economists who can nerd out about all of the complexities around leakage and cap and trade program design. And those are 3 radically different expertise sets that I don't see concentrated in any single institution right now. And again, I think the challenge is to do this right means all 3 of those communities being in dialogue. And that to me is the challenge, because to me the legally most robust path to a carbon price is one that is rooted in state law, passed through an ISO or RTO under Section 205 of the Federal Power Act, and blessed by FERC as accommodating a just and reasonable outcome. And that means all of these players have to get together and solve those issues together, and that's the challenge.
So if the Dormant Commerce Clause is a legal consideration or restriction on state regulatory action, not necessarily on the RTO's action, what role, if any, does the RTO have in designing its markets to help implement the state policy like California has, as we heard from Dawn? What role does the RTO have in helping mediate some of those disputes? Are there things that it can do that will lessen the risk for state law challenge in this interconnected electricity system? And the reason I'm asking is, in California, these issues are a little bit more developed, but in PJM, a number of states actually have some legal requirements to address leakage, and they operate in an even more integrated electric system than even the EIM is. And so they need to be thinking about, okay, what do we do, and have come to PJM, or some people have come to PJM and asked for some help in making that work. So what kind of lessons can we draw from the California experience for what the RTO can do in helping address some of these concerns? Anyone?
I'll say, I think at the end of the day, a lot of these issues are going to be decided by the environmental regulators. And so to the extent the ISOs can be playing a constructive role in trying to find creative solutions, that's the best spot. But I think the problem is the ISO doesn't control how the state regulator responds to these issues. And so if there's a disconnect between the way you want to run a market and the way you want to mitigate the environmental side of this, there's no direct legal or political leverage other than making the best possible case in a collaborative structure. And I think that's extraordinarily important because These are technically complicated issues, and if I had to put my finger in the wind and guess at which entity in California would be better at estimating leakage as between our climate regulator and our grid operator, I'd pick the grid operator. But that's not legally who does that right now. So I think that's the tension, and I think for other jurisdictions, and this again is probably most relevant in PJM and RGGI, maybe a little bit less in New York, making sure that there's harmony between those approaches in a rich and robust conversation is the most important thing people can do.
I was just a footnote on that, which Gary was talking about earlier, and I think you're implying here. I mean, we've been talking a lot about the Sue Tierney rule of let's get everybody to row in the same direction. But as Gary knows all too well, the states in PJM are not rowing in the same direction, and so the FPA doesn't sort of distinguish between the states that have climate policies and the states that don't when it reserves them the right to make their generation choices. And so it's just to emphasize how important it is to have the multi-state conversations because there are states in PJM that are frustrated that their climate policies are not carrying through. Some of that is from capacity market issues, but even in the energy market not being fully reflected. But there's also states there that absolutely don't want a carbon price. And I actually think that creates some common ground for a conversation about border adjustments or subregions in PJM, because it can, I think some of the coal-intensive states do run the risk of some of the states that have a legal obligation to figure out leakage one way or another, that they might be more affected by that than, notwithstanding Dormant Commerce Clause risks, more affected by that than if they could broker something through the RTO.
So let's go to some of the questions. So this will span both the sort of state version of carbon pricing implemented by the RTO or assisted by the RTO and some of the versions we talked about before. One questioner asks about 206. So if 206 is harder, is it possible, so I'll just read it. How do we bring carbon reduction to red states if there's no, if 206 isn't on the table? Are you comfortable asserting that FERC is powerless to implement carbon pricing in states that maybe aren't as excited about that?
I want to say something about this 205, 206 thing. Is this working?
Maybe closer.
Okay. So it is true that FERC has two burdens to fulfill when it's acting under Section 206. But the ultimate question is basically the same. And I think it's fair to think that what you might see in this area is a bubbling up. Multiple ISOs and RTOs try this and then send their proposals to FERC, and over time, those get approved, and slowly but surely, it kind of grows. That's what happened with demand response, and eventually, FERC responded and used 206 to implement a program. And I think you could see, I think it's reasonable to think that that is the most likely route for this to go. That means that 206 isn't off the table. It could be on the table. It's just a little ways off. We need to have some bubbling up. We need the ISOs, RTOs, to get the support they need from the states and to get their programs in. And then it bubbles enough that finally FERC comes in and says, well, if you don't have this, maybe because of the border adjustment problem is causing all sorts of issues, or, because you don't have just and reasonable rates, if you don't have an efficient market, then they come in with 206. That's my vision for the future.
Any reactions to that?
I can see it playing out somewhat like that. I would take issue with the fact that 205 and 206 boil down to the same question, because I think establishing that an existing rate is unjust and unreasonable is very different from establishing that a rate is just and reasonable. And so I do think there's an added hurdle there, which is what Danny was alluding to. But I hope your vision comes true. I think certainly some of the arguments that we've talked about, particularly the state policy argument, is much better suited to a state that has strong climate policy, obviously. The theory that Bethany talked about could apply a bit more broadly. There's a separate theory that views carbon pricing as a way of accounting for the cost that carbon emissions and climate change impose specifically on the electricity system that could perhaps apply more broadly, but there's definitely a challenge in applying this in different places.
Look, we have one voluntary carbon price under a 205 tariff. I hope there will be more, and some of these conversations may produce a couple of them. I don't think any of them is heading towards forcing a carbon price on a state that doesn't want it. And I think rather than 206 being the outcome, which again, intellectually makes a great deal of sense, I would like to live in that world, EPA regulation is going to happen first. And if that's struck down by the courts, you're going to see legislative negotiation. So I think that path is much more plausible than one in which FERC tries to impose this on people who don't want it. And I think, at least from my personal point of view, FERC's ability to move clean energy and climate priorities has more to do with structuring open, competitive, reasonable markets that people like and good things win in them.
Yeah, I was just going to say that I was going to have a really dangerous response to this because it's going to be more economic than legal. But I think some of this is just, even with all the noise, more carbon intensive generating units are becoming uneconomic. And I think if there's some reinforcing market signals here, and I think Nicole talked about this earlier, of just sort of having that signal that drives new innovation and brings costs down of no carbon technologies, I feel like that's useful at a sub-national level and can bring along other states who see this then as an economic development tool down the road. That's very cheery and also outside of my discipline, so dangerous in two ways.
One questioner, maybe I can characterize it as pushes back a little bit on the question about whether 205 and 206 are that different in this context. I mean, clearly there's different burden, but the question is about whether the harder part is actually overcoming some of these questions about FERC jurisdiction over environmental concerns, and whether that applies differently, whether one is accepting a Section 205 filing by the RTO or mandating a change after a complaint or on FERC's own action under 206. Do you have any thoughts about, does moving under 205 mitigate any of the difficulty about the concerns about FERC acting as an environmental regulator outside of its sort of statutory authority?
I think, yeah, I think that helps. And it's one of the reasons I favor the state carbon price integration approach. The more this is done from the bottom up, the less of a risk that FERC will come in and say, here's a $3 carbon price that applies to everybody, and that's the end of climate policy, which I think is an awful outcome and, frankly, in the hands of the wrong people could be done. So the more this is done carefully from the bottom up, I think the more it insulates against legal criticisms that the agency's acting outside of its authority, as well as creating clear precedent for accommodating multiple priorities in a federalist cooperative structure, which we had until not that long ago.
While I look at more questions, Romany, one thing you said jumped out at me, which is you started talking about the theory about climate change itself affecting the ability of generators to generate, maybe the ability, the incentive of consumers to consume, and that maybe that in and of itself has some effect on rates that can then provide FERC a greater jurisdictional hook. I wonder, though, that raises the question to me about how the jurisdictional argument relates to the design of the policy, right? The basis on which you are finding that FERC has jurisdiction to act, does that impact what the market design has to look like? And if so, how should we think about that question in the context of some of these different theories, the externality theory, the harmonization theory, the climate sort of effects on the generation sector theory?
Yeah, I mean, I will start, but I'm sure others have thoughts. Definitely, I think the theory that is relied on does have implications for the design of the program. Just one example, I think the price level is really important to think about in light of the justification that's relied upon. If you're viewing this as a way of integrating state policy, then you really should be looking, as was said in the New York context, to the state to provide some guidance on what is an appropriate price level. If you're relying on a justification that is linked to the impacts that emissions and associated climate change have specifically on the electricity sector, then perhaps a broad social cost of carbon doesn't make sense in that context. So I do think that there's important design questions that relate to and feed into the justification questions, absolutely.
Bethany, have you thought about how the externality theory informs the design of the...
Yeah, I mean, if you're trying to internalize the external cost of social cost of carbon, then you should look at the damages that each additional unit of electricity are producing and price that through, by looking at a well-recognized tool that's been vetted by 14 agencies under the previous administration. and is being applied in all the states that have thought about this. You know, this, I'm talking about the social cost of carbon that was prepared by the Interagency Working Group. It's been vetted, it's consistently seen as the best available estimate for the external cost of an additional unit of carbon emissions. And every state that has so far needed to use this price for something, either in planning or in pricing zero emissions credits, or in multiple other contexts, has relied on the Interagency Working Group social cost of carbon. So it's getting endorsement across the board at the state level, and it was, getting endorsement at the federal level. Right now, there's a move away from it, but it shouldn't matter because the states are still applying the Interagency Working Group's number. So that's something to that these programs can look to for purposes of pricing. The other thing I just want to say is, there is sort of, we have to be careful that the states aren't setting the wholesale market carbon price, right? Because states aren't allowed to set the wholesale rate. They're not allowed to replace it. They can't maintain control over that. I think the better way to look at this is if you have a state that's doing carbon pricing, then that's a separate state program that's outside the wholesale market, and the RTO does its own thing to include that in the RTO wholesale rates. You don't want the state trying to replace the wholesale rate, because then you run afoul of preemption concerns. I mean, there is a lot that the state can rely on to protect its programs. Like I said before, this is an area of traditional state control, but a state isn't allowed to replace the wholesale rate.
I'll just add really briefly, there are theories where FERC determines that price, and there's theories where FERC accommodates a state decision on that. And I think the accommodation puts FERC in a less uncomfortable position. We could have a debate about what the right price is and so forth, but if FERC isn't saying that, if FERC is just saying this is what the states are doing, we're putting the pieces together to make the system work, I think that's an easier lift for the agency, even if all the explicit carbon prices are lower than the legacy social cost of carbon.
Does that raise the issue that Bethany just mentioned about the sort of one takeaway from the Hughes case about states not not replacing wholesale rates? Is there some principle that lives there that sort of limits the amount of state involvement in what is ultimately a FERC decision?
Yeah, I mean, look, every historical environmental regulation affects wholesale rates. We don't strike down local environmental regulations. And the Hughes, I think the great example would be the ZEC cases out of the Second and Seventh Circuit, where you say you're not clearly tethered to the wholesale market. I think those cases present much closer questions than the question of accommodating a state-level carbon price. That looks like a traditional environmental regulation. So at least from my perspective, I don't see that as a major concern. Rhetorically, it's something you might hear, but I don't find it legally compelling.
Yeah, I think post ZECs, I think Hughes may be narrowed to you couldn't condition the subsidy on participation in the wholesale market. Maybe a little bit more than that, but I think there's definitely a way to design. I'm also thinking with this sort of rationale and then design, I wonder if there isn't a little bit of a self-limiting principle in there for FERC or a FERC jurisdictional market that would avoid the nightmare scenario that Danny was talking about, in that because there is these traditional powers reserved to the states, I'm not sure FERC could set a price with the intention of displacing state generation choices and thereby preempting. I don't mean to be cavalier about it. It's obviously, this is super complicated. We have to think a lot about it. But I do think that would be a very hard intention to design in a way that wouldn't then be obviously getting FERC out of their lane in the Federal Power Act.
Yeah, so the next question was about this preemption concern, and I wonder if you all have thoughts on similar. So does FERC's motivation in implementing a carbon price and the state's motivation in their own policies, whether that be subsidies or a carbon price of their own, like RGGI, does having different motivations and purposes, different targets that they're aiming at maybe, influence the risk of preemption that we should consider? And another spin on that is, like, are there things the states can do to kind of mitigate that risk, even if FERC were to approve one of these things?
Yeah, just briefly, I'm sure everybody wants to talk about this, but as Kate said, they have to stay in their lane, and that's how you figure out whether they have. You look at the targets. FERC can regulate demand response because its justification was all about and only about the wholesale markets. And states can have carbon pricing if they're doing it for purposes of emissions control or whatever, and not trying to replace the wholesale rate. You know, the reason the ZEX programs survived is because it was clear from the way the program was structured that that the states weren't trying to replace the wholesale rate. They were allowing generators to get these subsidies regardless of whether they participated in the wholesale markets. So you can't say that those programs are set out to replace the wholesale rate.
I'll just say go step by step. I mean, I don't want to belabor the point, but I mean, for folks who aren't following the California situation, there was a big political debate in the last couple of years about whether or not to dissolve the state-controlled governance structure of CAISO to facilitate a regional expansion. And one of the issues that came up in that process is what happens to all these state policies that have traditionally been preserved, and I think CAISO has managed very effectively. If you get rid of that governance structure and replace it with something TBD dominated by Western states with different policy priorities. And whatever you make of the outcome of that debate, we were going to have to figure out a structure on the carbon price that accommodated the people who didn't want to be subject to it and the people who did want to be subject to it. And so it's kind of interesting how much farther ahead that debate was than these very important and I think essential issues to work on. The slower you go, the more careful and cooperative, the better the posture vis-a-vis all the legal risks, because FERC could come in and say, we don't like that in the future. So the more it's a case-by-case, building a record, showing the precedent of cooperation, the harder it is to rock the boat.
There was a question about that, built on that, about whether we're counting out the opportunity for carbon pricing in multi-state RTOs. California's got a particular governance structure in which CAISO has to be particularly responsive to one state's policy preferences. And Dan, I wonder if from your experience there or anyone else's experience, you know, I think there's some question about whether the stakeholder process in the RTOs actually reflects state preferences or not, and how should we think about you know, the sort of whether the possibility for moving forward in a multi-state RTO sort of context.
So I'll just say, I mean, I think in the Western context, it's essential that California has a veto and everybody else has a veto. And I think that's kind of what the EIM structure is about. If the EIM governing body doesn't like something, they can push back. Similarly, if something goes totally against California principles, at least in theory, the CAISO board could push back. I think they're not, you know, the confirmation and appointments process is not the same thing as the tight control I think a lot of people assume it would be. But the idea that we should have more state involvement in the governance, I think, is a very positive one. And one in which, if you want a regional market that includes people who are subject to carbon pricing and people who are not, you need to have an agreement. And that is typically best done when one side can't dominate the other. And I think all of the problems in these negotiations have come down to one side trying to dominate the other. And that, I don't see that working out very well. And I think the more that could be done cooperatively, the better. And again, I mean, I don't want to speak for the CAISO stakeholders and the EIM stakeholders, but I suspect if California tried to impose its carbon price on people who didn't want to be subject to it in the West, everyone would walk. That's good, right? That from the standpoint of everybody's ability to collaboratively negotiate, as much as I would love to impose the carbon price on everybody.
So one issue that we haven't talked about that I just want to hit on quickly, we're basically at the end of the time, is the revenue question. That came up in one of the prior panels, and I just am curious if anyone in the sort of a lightning round style has any quick thoughts on what the legal principles or limits are on what to do with revenue, excess revenue that's generated as a result of imposing a carbon price on the system.
Okay, so lightning round. So I think you should look at this from an economic perspective. You know, what are we doing with the signals? And that NYSO's plan sounds great.
Yeah, in the spirit of that, I think NYSO's on the right path there. I find this super fascinating, though, and feel like a lot more work needs to be done here to get creative about what to do with these revenues.
It's a 205 filing with NYSO, and so whatever passes 205 muster works. When it comes to integrating state carbon prices, whatever the states do is fine.
Is there any limit? I mean, could the RTO give the revenue to, you know, a non-market participant?
Again, if it's just imposing liability,
yeah,
if you're just imposing liability, the FERC has no and the ISO has no control over that. So it's kind of whatever the state does. I think it's really interesting on the state side.
Well, both are important.
I mean, I think it's safer ground if it's returned to market participants. You know, that is traditionally within the ISO RTOs. mandate and area of operation. Also, there are sort of precedents for that type of thing happening with the transmission congestion charges and the like. So I definitely think that it's on safer ground.
Great. Okay, I think that's it for timing. Thank you to everyone, and look forward to more discussion. Okay, so lunch is outside. Please go out and pick it up, and then we will be resuming at 12:45, I believe, here with a conversation between Rod Cuckrow and Sudeen Kelly. Thanks.